a tragic case that occurred back in July that ultimately resulted in the death of the East Branch Fire Department Assistant Chief. I'm joined here by the Troop C Commander, Major Lucas Shuda, the Delaware District Attorney's Office, and District Attorney Sean Smith, and also members of the Bureau of Criminal Investigation. First, Major Lucas Shuda will be providing a synopsis, and following that, District Attorney Smith will discuss what was brought before the grand jury. Major.
Thank you. Good afternoon. On July 17th, at approximately 9:30 p.m., state police members assigned to SP Deposit investigated a one-car motor vehicle accident on State Route 30 in the town of Hancock, where a 2024 GMC Sierra, operated by Joseph Bellows Jr., left the roadway and struck a utility pole. This accident resulted in live power lines to become dislodged and fall to the ground around the accident scene. First responders, including East Branch Assistant Fire Chief Jason T. McGlone, were subsequently dispatched to the scene. Upon arriving, Chief McGlone's vehicle, an East Branch rescue pumper, came into contact with a live wire. As Chief McGlone exited his vehicle, he was tragically electrocuted and killed. Following a thorough investigation, this case was presented to a Delaware County grand jury who indicted Mr. Bellows on a number of charges yesterday. These charges will now be discussed by Delaware County District Attorney Sean Smith.
Thank you. Thank you. So I just want to preface everything that I say here. This is the defendant, just like any defendant, is presumed innocent unless he's proven guilty. So everything I talk about are allegations. There's been an indictment, but that doesn't mean he's been convicted yet. So first thing, the reason why I think it's important to do this press conference to update everybody. I know there's been a lot of questions from the family members, from the firemen, reaching out to my office and the state police. But in a case like this, obviously they have to do an investigation. We have to put it together to make sure everything's done before we just run out and have them make an arrest. There's a lot of stuff that goes into that, and I understand it may seem like it took a long time from the public perspective, but in reality, the state police, everybody here was working around the clock. They had people called in from their vacations. They were working overtime and on the holiday weekends. And from July 17th, when the crash happened, till yesterday, when the defendant got indicted, I would say nonstop, more or less, the state police had been working on everything that went into this case. So yesterday, we presented the case to the grand jury. The defendant was picked up yesterday on a sealed indictment arrest warrant. He was arraigned a little while ago today, and the indictment was unsealed. So the charges, count one of the indictment, alleges that the defendant was speeding while he was operating his motor vehicle. Count two alleges that the defendant was on his cell phone while he was operating his motor vehicle at the time of or right immediately before the crash. Count three alleges that the defendant was intoxicated by alcohol while he was driving his vehicle at the time of the crash, in violation of Vehicle and Traffic Law Section 1192(3). There's a separate charge. There's two DWI charges. One is what we call common law DWI, which is just somebody's intoxicated. And then there's another DWI in violation of Vehicle and Traffic Law Section 1192(2), which has to do with per se, where the defendant's blood alcohol content is alleged to be above 0.08 is the legal limit. So each of those DWIs goes into counts 5 and 6. Counts 5 and 6 each charge vehicular manslaughter in the second degree, a Class D felony. And the reason why there's two counts is that statute says that if you cause the death of another person while you're operating a vehicle in violation of any subdivision of 1192, then it's vehicular manslaughter in the second degree. So since there were two separate theories of DWI, there's two separate theories of manslaughter. That's a Class D felony. If the defendant's convicted of it, he faces up to 2 1/3 to 7 years in state prison. Count 7 of the indictment is manslaughter in the second degree. And the allegations there are that the defendant acted recklessly in causing the death of the other individual. And recklessness there is a culmination of all the other counts that I just mentioned as we led up to the speed, the DWI, the cell phone, all that stuff goes to the recklessness. And that's the most serious charge. That's a Class C felony. And if the defendant was to be convicted of it, he faces a maximum sentence of between 5 and 15 years in state prison. There's also a misdemeanor count of criminal mischief in the fourth degree, which has to do with the allegations are that he damaged property belonging to another person. That would be NYSP for the cost of the pole and the power lines to replace it. So those are the allegations that are in the indictment. Like I said, the defendant was just arraigned probably half an hour ago today. My office requested that the judge set bail, and I believe my ADA requested $100,000 bail. The judge ended up setting bail at $10,000. As far as I know, the defendant's being held. Whether he posts bail or not, I don't know. We'll see how that goes, and I'm happy to answer any questions about the case to the extent that I can. It's an ongoing case. It's going to be going to court, so some things I may not be able to answer, or the state police may not be able to answer, but if we can, I'm happy to take any questions.
Can you go over the time he'd be facing for each of the charges that you mentioned?
Yeah. And I just want to say that even though there's 3 forms of manslaughter charged here, it's not like he could get convicted of all 3 of those and add on to each other. They're each different theories for the same person that was killed. So the most serious charge is manslaughter in the 2nd degree, and that could be as low as, the judge ultimately has discretion, could be as low as a determinate term in local jail to a maximum of between 5 and 15 years in state prison. The way it's classified, it's an indeterminate sentence, which means that he'd do at least 5 years in state prison, and whether he gets out 6, 7, 8, up to 15 would be up to the parole board. Vehicular manslaughter, if he got convicted of that, would be concurrent to the manslaughter charge, but that one, same thing, would be an indeterminate term of 2 1/3 years being the minimum to 7 years being the maximum.
So the maximum would be 15 years.
Yeah, 5 to 15. Yep. Yep. I guess the issue with that is what we can say is the defendant refused the test initially that the state police wanted to do. They got a search warrant and they determined it later, but we have a toxicology report that alleges it's over the legal limit. Our theory on it, I don't want to get into what we're going to argue it was or what we expected it was, because he may disagree with that if it comes to a trial or something. Anybody else have any questions? I just want to say I really appreciate working with the state police on this case. It's anytime there's a homicide, it's really difficult. No matter what they do, no matter what we do, we can never bring back the person that was lost, the family member. But working with this group of folks here, they've been really great. Anything we've ever needed, they're on it, and they help us every way we can. And I really appreciate that.
Thank you, everyone. And as I mentioned prior to the press conference, please respect the family's wishes. They would like their privacy at this time. So, thank you for coming out.